Modern Real Estate Practice, page 318. Survey. A survey provides information about the exact location and size of the property. Typically, the survey indicates the location of all buildings, driveways, fences, and other improvements located on the premises. The survey should also indicate any existing easements and encroachments. The cost of the survey is negotiated in the sales contract. The survey is important in verifying the legal description of the property. In practice, relying on an old survey is not a good idea. The property should be resurveyed prior to closing, even in the rare instance that it is not required by the title company or lender. A current survey confirms that the property purchased is exactly what the buyer wants, and that no encroachments have arisen since the last transfer of title. Title evidence. The buyer and the buyer's lender will require that the seller's title comply with the terms of the real estate contract. Although practices vary from state to state, most require that the seller produce a current abstract of title or title commitment from a title insurance company. When an abstract of title is issued, the purchaser's attorney examines it and issues an opinion of title. The attorney's opinion of title is a statement of the quality of the seller's title, and it lists all liens, encumbrances, easements, conditions, and restrictions that appear in the record and to which the seller's title is subject. The attorney's opinion is not a guarantee of title. You previously learned about how ownership is proven and the importance of examining the chain of title for various defects. When the purchaser pays cash or obtains a new loan to purchase the property, the seller's existing loan is paid in full and satisfied on the record. The exact amount required to pay the existing loan is provided in a current payoff statement from the lender, effective the date of closing. The payoff statement notes the unpaid amount of principal and the interest due through the date of the proposed payment. The fee for issuing the certificate of satisfaction or release deed, credits to the seller, if any, for tax and insurance reserves, and the amount of any prepayment penalty. The same procedure is followed for any other liens, such as a second mortgage or home equity loan that must be released before the buyer takes title. If the buyer assumes the seller's existing mortgage loan, the buyer needs to know the exact balance of the loan as of the closing date. Usually, the lender is required to provide the buyer with a mortgage reduction certificate, which certifies the amount owed on the mortgage loan, the interest rate, and the date and amount of the last interest payment. The closing agent examines the title commitment or the abstract that was issued several days or weeks before the closing. Because liens may have been filed during the interval, 2 searches of the public record are often made. The first search shows the status of the seller's title on that date. The second search, known as a bring down, is made after the closing and before any new documents are filed. As part of the later search, the seller may be required to execute an affidavit of title, a sworn statement in which the seller assures the title insurance company and the buyer that no other defects in the title have occurred since the date of since the date of the title examination. For instance, judgments, bankruptcies, divorce, unrecorded deeds, or contracts, unpaid repairs or improvements that might lead to mechanics liens. The affidavit gives the title insurance company a basis on which to sue the seller should the statements in the affidavit be incorrect. The title or opinion of title discloses all liens, encumbrances, easements, conditions, and restrictions on the property. End of page.